Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object and object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled, under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.